Question 586. Upon an agent's disclosure of dual agency to the parties, if the parties consent to such an agency, it must A. Be relayed to the state attorney's office, B. Occur at least 30 days before the close of a transaction, C. Disclosure of a dual agency is not required, D. Be in writing. Correct answer is D. Be in writing. There is no requirement to report the consent to dual agency to the state attorney's office. The disclosure and consent are primarily between the agent and the principals, buyer and seller. The California Department of Real Estate, DRE, oversees real estate licensees, but routine dual agency consent isn't reported to the state attorney. While early disclosure is good practice, there isn't a specific requirement for the written consent to dual agency to occur at least 30 days before closing. It must happen before or at the time the parties enter into a contract. When an agent discloses dual agency, representing both the buyer and the seller in the same transaction, to all parties involved, their consent to this arrangement must be in writing. This requirement ensures that all parties understand the implications of dual agency and provide explicit, documented agreement to it. Question 587. The difference between the nominal rate of interest and the effective rate is A. The nominal interest rate is what is specified in the actual loan. The effective rate is what the borrower actually pays in interest. B. The nominal interest rate is specified in the actual loan. The effective rate is what borrowers are paying for a similar property. C. The nominal interest rate is the rate proposed by the borrower in negotiations with the lender. The effective rate is what the lender wants the borrower to pay. D. There is no difference between the nominal and effective rates. Correct answer is A. The nominal interest rate is what is specified in the actual loan. The effective rate is what the borrower actually pays in interest. Nominal interest rate is the stated or advertised interest rate on a loan. It's the rate written into the loan agreement. Effective interest rate is the actual rate the borrower pays when considering all the costs associated with the loan. It can differ from the nominal rate due to factors like 1. Compounding frequency. Interest compounded more frequently, e.g., monthly versus annually, results in a higher effective rate. 2. Fees and charges. Loan origination fees, discount points, and other charges increase the total cost of borrowing, thus raising the effective rate. 3. Prepaid interest. If interest is paid up front, the effective rate over the loan term can be higher. Question 588. An owner tells his listing agent that his home being sold, has a leaky roof. The listing agent should A. Tell the owner to paint over any water spots that indicate there is a leak, B. Disclose the fact that the roof leaks to prospective purchasers. C. Not disclose the fact that the roof leaks to prospective purchasers because it is not a material fact. D. Disclose the fact that the roof leaks to prospective purchasers only if the purchasers ask specifically about any problems with the roof. Correct answer is B. Disclose the fact that the roof leaks to prospective purchasers. Real estate agents in California have a fiduciary duty to their clients, the seller, but also a duty of honesty and fair dealing to all parties in a transaction, including prospective buyers. This includes disclosing all known material facts about the property that could affect its value or desirability. A leaky roof is undoubtedly a material fact. Selling a property, as is, does not relieve the seller or the agent of the duty to disclose known material defects. As is generally means the seller will not make repairs, but it doesn't negate the requirement for transparency about the property's condition. The duty to disclose known material facts exists regardless of whether the buyer asks specific questions. Agents cannot wait for buyers to stumble upon problems, they must proactively disclose known issues. Buyers still have the right to know what they are buying. Concealing a known leaky roof from a buyer can be seen as misrepresentation or even fraud. Paint over any water spots is unethical and potentially illegal. It's an attempt to conceal a known defect, which violates the agent's duty of honesty and fair dealing. If the buyer later discovers the undisclosed issue and proves the seller and agent were aware of it, they could face legal consequences for this lack of transparency. Question 589. The right of a utility company to string power lines across privately owned land is an example of A. Zoning ordinance, B. Eminent domain, C. Encumbrance, D. Condemnation. Correct answer is C. Encumbrance. Zoning ordinances regulate land use and development within a specific jurisdiction. They wouldn't directly address a utility company's right to install power lines. Eminent domain is the legal power of the government, or entities authorized by the government, to acquire private property for public use, often with just compensation to the owner. While eminent domain could be used to acquire land for power lines, it's not the term that describes the ongoing right of the utility company to use the land. Condemnation is the legal process by which the government exercises its power of eminent domain. Similar to eminent domain, it focuses on the acquisition of property, not the ongoing right to use it. Encumbrance is the most accurate answer. An encumbrance is a right or interest in a property that affects its ownership and limits what the owner can do with it. In this case, the utility company's right to have power lines on the property is an encumbrance on the private landowner's ownership. The landowner cannot completely exclude the utility company from the property for the purpose of maintaining the power lines. An easement in gross is an easement that is not created to benefit a particular parcel of land, but to benefit a specific user, in this case a power company. Easements in gross are in the larger category of encumbrances. Question 590. Broker Dolores sells a home listed by a broker from another brokerage. Her arrangement with the listing broker can be described as A. Selling broker, B. Third party, C. Co-agent, D. Principal. Correct answer is A. Selling broker. When a broker, like Dolores, from one brokerage finds a buyer for a property listed by another brokerage, they are acting as the selling broker or selling agent. They sell the property to their buyer client, even though they don't hold the listing agreement with the seller. They cooperate with the listing broker to facilitate the transaction. While Dolores is a third party to the listing agreement between the seller and the listing broker, this term doesn't specifically describe her role in the cooperative sale. A co-agent typically works for the same brokerage as the listing agent and assists in marketing and selling the property on behalf of that brokerage's client, the seller. Dolores works for a different brokerage. The principal in this scenario is the seller, who hired the listing broker, and the buyer, who hired Dolores, implicitly or explicitly through their working relationship. Dolores is acting as an agent for the buyer. Therefore, the most accurate description of broker Dolores in this situation is a selling broker or a cooperating broker. Question 591. A licensee who misrepresents property to the buyer while acting as an agent of the seller is subject to A. Lawsuits, B. Discipline, C. Criminal penalties, D. All of the above. Correct answer is D. All of the above. Licensees making misrepresentations are subject to discipline, civil lawsuits, and/or criminal penalties. The buyer can sue the licensee, and potentially the seller and the brokerage, for damages resulting from the misrepresentation. This could include claims for fraud, negligent misrepresentation, breach of duty, and more. The State Real Estate Licensing Authority, in California, the Department of Real Estate DRE, can investigate the licensee's conduct. If found to have misrepresented the property, the licensee could face disciplinary actions such as 1. License suspension, temporarily losing the right to practice real estate. 2. License revocation, permanently losing the right to practice real estate. 3. Fines, monetary penalties. 4. Probation, restrictions or conditions placed on the license. 5. Reprimand, a formal warning placed on the licensee's record. In cases of intentional and significant misrepresentation or fraud, especially if it involves financial harm to the buyer, the licensee could potentially face criminal charges. This is less common than lawsuits or disciplinary actions but is a possibility in egregious situations. Question 592. While an estate for years automatically terminates when the agreed term expires, the lease can be ended before its expiration date with the tenant's consent. Such early termination is called A. Tender, B. Demise, C. Surrender, D. Reliction. Correct answer is C. Surrender. A tender is an offer to perform an obligation or pay a debt. It's not related to the early termination of a lease by mutual agreement. A demise is the transfer of an estate and property, particularly a leasehold, from the landlord to the tenant. It describes the creation of the lease, not its early termination. Reliction refers to the gradual recession of water from land, permanently exposing dry land. This is a concept related to property boundaries and water rights, not lease termination. A surrender in landlord-tenant law is the tenant's voluntary return of the leased property to the landlord before the lease ends, which the landlord must accept. The tenant's consent is a key element of a surrender. Question 593. An open-end provision in a mortgage would benefit a borrower who wishes to A. Gain a discounted interest rate, B. Allow a subsequent purchaser to assume the loan, C. Borrow additional funds, D. Secure the loan with several different properties. Correct answer is C. Borrow additional funds. Interest rate discounts are usually negotiated separately based on creditworthiness, market conditions, or specific loan programs, not directly tied to an open-end provision. The ability for a subsequent purchaser to take over the loan is related to an assumption clause, not an open-end provision. Securing a loan with multiple properties is known as a blanket mortgage, not an open-end mortgage. An open-end mortgage allows the borrower to reborrow up to the original loan amount after a portion of the principal has been repaid, without having to refinance the entire loan. This feature is advantageous for borrowers who anticipate needing additional funds in the future for things like home improvements or other expenses. They can effectively increase their loan balance back up to the original limit. Question 594. A verbal contract is called A. Invalid, B. Non-enforceable, C. Parole contract, D. Orally based agreement. Correct answer is C. Parole contract. Not all verbal contracts are invalid. They can be legally binding under certain circumstances. Some verbal contracts might be difficult to enforce due to lack of evidence. They aren't necessarily unenforceable altogether. Orally based agreement is a general description but doesn't have the specific legal term used for verbal contracts. Parole contract is a legal term that refers to a verbal or unwritten agreement. The word parole means verbal. It's important to note that enforceability of parole contracts can vary depending on the specific situation and jurisdiction. Some states have a statute of frauds that requires certain types of contracts to be in writing to be enforceable. Question 595. To create an escrow agreement, there needs to be A. Oral agreement, B. Binding contract, C. Personal property, D. All of the above. Correct answer is B. Binding contract. An escrow agreement is a mechanism used to facilitate the terms of an underlying binding contract between two or more parties. The escrow agreement outlines the conditions under which the escrow agent will hold and disburse funds and/or documents. Without a valid contract establishing the obligations of the parties, there's no basis for the escrow agent's actions. While parties might have preliminary oral discussions, the escrow agreement itself is typically a written contract. Furthermore, the underlying agreement necessitating the escrow, like a real estate purchase agreement, usually needs to be in writing to be enforceable under the statute of frauds. While escrow can be used for the transfer of personal property, it is most commonly associated with real estate transactions, which involve real property. The existence of personal property is not a requirement for creating an escrow agreement. Therefore, the fundamental prerequisite for creating a valid escrow agreement is the existence of a binding contract between the parties outlining the transaction that the escrow will facilitate.